Okay, class, in this video, I want to look at 3 different reasons why somebody, okay, or why an employee may feel that they have been wrongfully terminated from their work, okay? So we've said that employment at will, the employer and the employee can terminate the employment agreement at any time for really any reason, okay? Now, we're going to look at exceptions to an employment at will, okay, and legal challenges that can be presented by employees if they feel like they've been wrongfully terminated. Okay, so the first one, an implied contract, okay? The definition is a contract that exists when an employer has said, written, or done something to lead an employee to reasonably believe that he or she is not an at-will employee. Okay, so the employer has done something, okay, that has made the employee think that it's not at-will employment, and therefore they can't be let go anytime for any reason. Okay, now what the courts are going to do is they're going to look at all the facts. Okay, they're not going to look at just the oral promises that were made by the employer, but they're going to look at the entire situation to determine if there was an implied contract. Okay, essentially, the employee believes they have a contracted position, okay, and should not be terminated. That's really the basis of this. The employer has done something that has led the employee to believe that there is no longer at-will employment, and therefore the employee thinks that they were, wrongfully terminated. Okay, they shouldn't have been fired. Okay, now the next example or circumstance would be public policy tort. Now, public policy tort, this is a legal theory, okay, and what it says, it allows a discharged employee to bring a wrongful discharge lawsuit, okay, meaning that they can take their employer to court over their termination against a former employer based on the argument that the firing somehow hurts the public at large, okay? It allows the fired employee to collect monetary damages in the courts if successful. Okay, so if there is some employee out there and they have some sort of job where they are responsible for the public health or the public safety or something along those lines, okay, and they've been let go from their job, and because of that, the public health and safety has been jeopardized. Okay, that person may be able to bring a public policy tort case against their employer to say that they were wrongfully terminated and be able to collect money from the employer. Okay, now the last example here is an implied covenant. Okay, now what an implied covenant is, it's a legal argument, okay, that holds or means that any employment relationship is based on an implied promise that the employer and the employee will be fair and honest with one another. Okay, so these implied covenants, they exist simply because there's an employment relationship. Okay, just based upon the fact that there is an employer who has agreed to hire an employee, there's an implied covenant. Okay, so essentially what this means is the employer needs to have a good cause in order to terminate the employee. It means that the employer can't just say anytime, anywhere, you're fired, thanks for your service, goodbye. They need to have a good reason in order to do it. Okay, and that would mean that employment at will really isn't the case anymore, okay, because employment at will means that the employer can let you go at any time. Okay, but the implied covenant is saying that if the employer is going to let you go, they need to have a good reason in order to do it. Okay, now implied covenant, this legal argument, it's been adopted by 37 states. Okay, so this applies in 37 states, where essentially your employer needs to have a good reason in order to terminate you. Okay, but Pennsylvania is not one of them. So implied covenants really don't apply to Pennsylvania. Okay, and that means that true employment at will still exists in our state.